Does that come with a side of cotton candy too, or?
Maybe it should. Got whipped cream. Yeah. Oh no, not IHS. IHS.
Hi, Melissa.
How are you?
Hey Melissa. I'm trying to get into one of the summer seminars.
Nice.
Hi.
What's your name?
April.
April. I'm Lee. McGrath. Nice to meet you. Tony. Hey, Tony. Good to meet you. Hi.
Melissa.
Hey, Melissa. Good to meet you.
Her group is growing, man.
Yeah, it is.
Danny. Lydia. Derek. Eric.
Yep.
Matt. Rob.
Sure.
Sorry.
Jim.
Jim.
Deal.
Sorry. Well, do you want to get started?
Sure. We kind of have, I don't know, we have a little agenda thrown together. It's double-sided.
Yeah, or there's two on each.
Yeah.
I meant to bring scissors.
Yeah.
It doesn't happen. Maybe not. So, yeah.
Throw one down that direction as well.
Or just write them myself, whatever. Does that work?
He's already prepared.
Oh, there you go. Not the man.
There you go.
So who all is state central alternate or delegate?
Delegate.
Anybody else? All right, you're a delegate? Who else is
Delegate.
still-
Delegates.
Oh, cool. I'm an alternate.
There's cross seating within the CDs at State Central too.
Oh, there is?
Mhm.
Oh,
So
really?
you can backfill open spots.
So how do
is
they
that-
figure out who goes first?
It still goes by rings, but they have such a historic problem with alternates not, or with people not showing up. That's why there's twice as many alternates to State Central as there is to anything else. Because everyone's like, why are there so many
Aaron,
alternates?
nice to meet you.
You'll see, nobody will show up.
21.
Yeah, nobody will show up.
I have a
Just
feeling
like when I
this is
sent
going to
the
be popular.
email the other day, who's going, he's like, I'm not going, I'm this alternate, I'm not going. It's like, well, if you're an alternate, you will get seated. So.
Yeah.
That's good then. Because at least for Harvard, that's really good.
What do you think the reason for that is?
People are
Just
burned
because
out.
people gotta drive so far, maybe, or?
No, it's just, I don't know.
People are burned out.
It's not as cool as,
Yeah.
as a regular state convention every couple of years. I don't know.
Yes.
Since there's a contested party chairman.
I think, yeah.
Crowded.
All right, so we'll go ahead. We have an agenda printed out. Kind of an introduction. We have some new faces here, so I think we already went around and kind of introduced ourselves. We can kind of do that again real quickly so everyone's kind of familiar with what's a name to a face. I'm Eric Taylor from Minnetonka.
That's it.
That's it.
And what do you do for Liberty Southwest, Eric?
I'm the president of Liberty Southwest.
Glorious leader.
Popeyes.
Oh, hi, I'm Matt Winter. I'm the vice president. I'm from Chanhassen.
Jim. Next.
I'm Tony, I'm from down in Shakopee, I'm the C2, I'm a state central delegate, and I helped start another PAC for Liberty, Minnesota.
Is it the Liberty Minnesota PAC? Is that?
That's the one.
That's
April Hitler.
I am Aaron, I'm the Libertarian Surgeon.
Sneaky.
Very good. I'm Lee McGrath. I'm the Executive Director of the Institute for Justice, Minnesota chapter.
I'm Melissa Simmons. I'm in Tucka Bay. I'm the regular attendee, I guess, of this group.
Where's Kirk?
At the bar.
He's coming. He's coming. He's assured me.
I'm Andrew Schmitz. Somehow I managed to become deputy treasurer. I don't know how that happened.
Well deserved.
I'm Danny. I'm from Chanhassen, St. Louis Park, and pretty soon New York.
It's kind of big.
And I'm the treasurer. Somewhere.
My name is Lydia Tabbitt, and I'm from Chanhassen, and I'm the secretary for Liberty Southwest.
And Derek Flom, I'm from Victoria, and I'm the covert information specialist. Also a state central alternate, And as of yesterday, I'm an official election volunteer coordinator for the Institute of Legislative Action for the National Rifle Association. So
Very cool.
pretty excited about that.
So I think maybe within the last month or so, Xavier Bickett, got a hold of Lee. I think initially we were planning on having David Gerson, Xavier, and Lee attend. There was a scheduling conflict that David had. So really the kind of the idea in talking with Xavier and also I think to a lesser extent Lee is to get an idea as to as to Lee's involvement in the liberty movement, how that kind of plays into the various forms of litigation and the practice of IJ at large, and kind of get a better understanding how that organization plays a role in liberty, libertarianism, and law in the state of Minnesota around the country. So.
Well, terrific. I'm thrilled to be here. Thank you for inviting me. The Institute for Justice is a self-proclaimed libertarian public interest law firm. So the quick and dirty way to think about us is we are the libertarian version of the ACLU. Most of our energy is spent suing the government when it violates our clients' constitutional rights. And we are supported by about 6,000 donors. They give us about $13 million a year. That allows us to employ about 65 people across the country. We're headquartered in Arlington, Virginia. We have state chapters in Minnesota, Washington State, Arizona, Texas, and Florida. And we have a clinic at the University of Chicago Law School. The type of things that we litigate are things that I think are near and dear to your hearts. First, we defend property rights, and we are best known for losing a Supreme Court case at the United States Supreme Court. We represented Suzette Kelo. She was the woman in New London, Connecticut, whose home was taken by eminent domain, not for a road or a government building, but for someone else's private development. We lost that case 5-4, but the public reaction to the idea that the government could take your home for someone else's private development was so strong that 45 states have changed their laws. Most of them now prohibit the thing that the United States Supreme Court said was constitutionally permissible, which is private taking, eminent domain for private use. We also litigate and lobby in the area of economic liberty. We've done about 60 cases. Half of them are challenges to occupational licensing laws. We don't like occupational licensing laws. We think it's a 21st century version of a medieval guild. It's very anti-competitive. The third area is we challenge speech regulations, particularly political speech regulations. We were an amicus in the Citizens United case. We brought a very important case that came out at the same time called Speech Now versus FEC, which really struck down the limits on, much more than Citizens United, struck down the limits on contributions to political action groups. And we defend school choice programs. So what I'd like to do tonight is to talk about the basis, our worldview, through the lens of litigation, through the lens of lobbying, and how we see the Constitution, how it has evolved, and what challenges are presented by advocates on the other side, advocates for a living Constitution, the modern progressive era. So with that, but before I do that, let me ask, are there any questions that you have about our cases, our litigation, that you'd like to talk about? What's your success rate? We have a pretty high success rate. We win about 7 out of 10 cases.
That's good.
And in part, it is, we have a very different model than a private law firm. Each of our attorneys has about 2 or 3 cases. By contrast, a private law firm, an attorney will have 50, 60, 70 cases. And so we think it's a huge competitive advantage just to pour quality into the case. And secondly, what we also do is we find really good clients. People who are very sympathetic, who
Who's easy to sympathize with.
who are very easy to sympathize with. And we present the clients to the judge in ways that say, Your Honor, you really want to rule for this person. We hit, not only do we make constitutional arguments, but we hit the absurdity button all the time in our litigation. It is just absurd that the city of Minneapolis does this. And that's a very effective way to
You
litigate.
guys try to get a lot to like the jurisprudence process and like, you know, the setting precedent, is that the goal? Or is
That is exactly the goal. So, most private litigators, devise a strategy of settling. They want to use the legal system, the costs of the legal system to settle cases. We want to litigate. We want decisions. We want to take things to go to trial, make motions for judgment, summary judgments.
You want to set a precedent.
We want to set a precedent. We take cases. When we select a case, one of the things we do is we say, does this case have implications beyond the client? So, why did we take Suzette Kilo's case into London, Connecticut? Because we liked Suzette. She was great. And tens of thousands of other people across the country were facing having their homes taken by eminent domain for private development. So winning for Suzette, losing for Suzette, had implications for other people. So, and that's the basic model of public interest law, that you attempt to set a precedent. Okay, good. So let's jump into sort of the meat and potatoes of tonight's discussion. So, what I'd like to talk about tonight is that there are 3 periods of constitutional thought. They are the original period, which we at the Institute for Justice, and I will offer you, really like, which is the initial idea of natural rights, that there is something above democracy. There's something above this legislator voting this way that controls you, that restricts your activity. That there is some higher law, greater law, a constitutional law that comes from who we are as individuals, comes from our nature. The next period that I'll focus on is after the Civil War. Through the Civil War, we really saw that government has changed from its original concept of the founders, where government was seen as a necessary evil, to evidence that government can really be evil through state-sponsored slavery. And then I'll finish up in this part of the discussion about constitutional history, constitutional approach with, hi, how are you? Here, come sit here.
All right, perfect.
I'm Lee McGrath.
Lee Kirk.
Kirk, nice to meet you. Do we have another copy? So, there you go, Kirk. So, we'll start off with the original idea that government is a necessary evil. Talk a little bit about how government was really evil, and then talk about the progressive era and modern progressive thought, where the whole world has changed, the political philosophy has changed. And hi there. I'm going to leave it there.
No, it's here for you now.
We have another one. What's your name?
Oh, there's one over
And
here.
let's get your first
Open the door.
Oh,
Oh,
nice to
can we
see
open
you.
these doors?
Huh?
Can I have another copy in my hand for Lee here?
Well, here, why don't I scoot here and then.
It might not be
We've
here.
got room over here for one more, so.
Let's just do this. Put this backpack against it,
Here we go.
and that'll probably hold it shut.
All right, why don't you
Here,
get
there.
this thing?
There.
No, it's all good.
Yeah, fine. Fine.
You only missed the introduction. So,
Except you got Lydia.
So.
It's gonna come in here.
What?
so,
Jack them up, they come through.
Absolutely.
so what we'll talk about then, we'll talk about the progressive era in which the worldview, the American view of government changed, I think mistakenly, but changed to the idea of government can really help you and make life better. And this is what we're currently battling at the Institute for Justice. The modern progressive state, the administrative state, the idea that better living through bureaucracy. And I can talk a little bit more detail about the type of cases that we do when we get to that.
Can you explain really quickly what this 1868 one is, the state-sponsored slavery?
Right. So after the Civil War, there were three important amendments to the Constitution: the 13th, 14th, and 15th Amendment. The 13th Amendment ended slavery. The 14th Amendment, and I'll get to this, opened the door to federal courts to all Americans, so that they could bring cases against state governments. It extended the rights under the Bill of Rights, under the Constitution, and applied them to the states.
Okay.
Okay? And the 15th Amendment guaranteed the right to vote for African American men. And we'll dive into that a little bit detail, because I'll submit to you that the 14th Amendment is just as important as the First Amendment. Okay, and we'll talk about it. We'll talk about that. So let's start back with the original idea from the Declaration. This idea that by your nature, who you are, you have certain rights, and these rights trump the democratic process. And from this, the idea of a superior law, of a constitution that is above the democratic process comes. That these rights are pre-political and cannot be changed. In essence, where does the right of self-defense comes from? Well, it is pre-political. It cannot be changed by the political process. So, you know, in the Declaration, the great preface by Jefferson, that we hold these truths to be self-evident, that all men are created equal, and they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. So rights do not come from the government. It wouldn't make any sense if the government had rights. Rights come from who we are as individuals. Jefferson takes a religious understanding of it. You can also see this in Aquinas, where Thomas Aquinas talks about levels of laws and God's law being the greatest. But you don't have to be religious about it. You can look to the Enlightenment and this idea of Locke, that there are certain things that are pre-political, that there are rights that exist that government cannot, we don't give government the power to change. We also see this in the Constitution, and most famously in the 9th Amendment, in which Madison writes that the enumeration in the Constitution of certain rights, like the right to free speech, the right to the free exercise of religion, the right to be safe and secure in your home and in your papers, shall not be construed to deny or disparage others retained by the people. That the people have lots of rights. And there's a famous discourse about the right to wear a hat. Can the government prohibit you from wearing a hat? Well, it's sort of a silly idea, but it speaks to the point that clearly no. The government cannot pass a law prohibiting your wearing a hat. Another way to think about it is, what if the First Amendment were not written? It was not put down as part of the Bill of Rights. Would you still have the freedom of speech? Would you still have the right to the free exercise of religion? The right to petition? Of course you would. The writing down of these rights in the Bill of Rights was less important than the recognition that who we are as individuals means that we are free to speak, and that these rights are inherent in our humanity. More recently, let me ask you to turn to page 3. We get a great example of this natural rights from Martin Luther King. So he's sitting in a jail cell in Birmingham, and he's writing to fellow Protestant ministers. He's writing to white ministers who are concerned about his advocacy of change and how fast he is attempting to change race relations. And I'll just read this and read along. He writes, "You express a great deal of anxiety over our willingness to break laws. This is certainly a legitimate concern, since we so diligently urged people to obey the Supreme Court's decision." Thank you. 1954, outlawing segregation in public schools. At first glance, it may seem rather paradoxical for us to consciously break laws. One may well ask, how can you advocate breaking some laws and obeying others? The answer lies in the fact that there are two types of laws, just and unjust. I'd be the first to advocate obeying just laws. One has not only a legal but a moral responsibility to obey just laws. Conversely, one has a moral responsibility to disobey unjust laws. Now, this is revolutionary. This is very revolutionary. The idea that you have an obligation, you have some affirmative responsibility to disobey unjust laws. But it goes to the point of his continuing, I would agree with St. Augustine that an unjust law is no law at all. Do you have some food for what? Somebody order some soup? Any soup takers? All right, very good. So King here is setting out the idea that there's something superior than just laws, that there's some way of looking at them as just and unjust. Now, what is the difference between the two? How does one determine whether a law is just or unjust? A just law is a man-made code that squares with the moral law or the law of God. An unjust law is a code that is out of harmony with the moral law. To put it in terms of Aquinas, St. Thomas Aquinas, an unjust law is a human law that is not rooted in eternal law or natural law. Any law that uplifts human personality is just. Any law that degrades human personality is unjust. All segregation statutes are unjust because segregation distorts the soul and damages the personality. It gives the segregator a false sense of superiority and the segregated a false sense of inferiority. So you can see that 180 years after the writing of the Constitution, in which Jefferson is speaking about these rights that we're endowed by, or after the writing of the Ninth Amendment and the Bill of Rights, Madison is talking about rights that aren't even enumerated. The King applies the same thinking. By our nature, government can't restrict certain activities. And of course, the great challenge is to find out what those are. But we have a terrific tradition in this country. We're blessed in this country of at least having the enumeration of rights in the Bill of Rights, as well as in state constitutions. So where do we go from there? Well, what we can see also is returning to Jefferson in the Declaration, he then tells us what the purpose of government is. Why does it exist? Why do we give power to government to control, to pass laws that restrict us? Well, magnificently, Jefferson writes in letter D here, the government's role is that to secure these rights, governments are instituted among men, deriving their just power from the consent of the governed. That government exists not to make life better, which we'll get to in the progressive era, but to protect life, liberty, and property. So you give government power to keep the burglar out of your home, protect your property. Not, by contrast with the modern progressive, to make the neighborhood nicer and your property values go up. The zoning laws and things like that. So this is the great foundation of constitutional law. This is what at the Institute for Justice we litigate these ideas that by our nature, you don't have to go to the religious connotation, but by our nature, we have certain rights that government just can't take away from us, regardless of the majority they get in the state legislature or the city council or in Congress. So let me stop there and just check in with you. Does this ring right to you? Give me your feedback on this idea of natural rights.
I think you're speaking for all of us.
All right, choir. So how does it ring to you, Matt?
Quite true.
Quite true?
Worth fighting for.
Worth it. Good. Yes, sir.
Oh, we got a week.
Very good.
Because today's, like my son was out with a friend, and he's 16, was out past curfew. But they were sitting on a bus bench, talking. And the police charged him with, what is it?
Loitering?
No.
Being out past curfew.
Wants him to plead guilty to that. Second one is record.
I don't know whether misdemeanors go on, or certainly if it's a felony, and it doesn't sound like a felony.
Yeah. He has the right, he's got the liberty, but liberty is promised by the Constitution. Whether he's a minor or not doesn't matter. The Constitution is for everyone.
Constitution is for everyone. But your question is really good, and we're going to get to the progressive era. Because in the progressive era, what changes, don't go that far. In the progressive era, what changes is the difference in the mindset of government. That government no longer exists to secure rights, to protect rights, to stop him from coming into your home. That is what government was supposed to mean. Two, what has changed, and I submit starting with Woodrow Wilson, what's changed is the government is now, in the progressive era, there to make life better. And when you empower government to make life better, the police ride around and look for young men, mysterious, potentially disturbing young men, idly sitting on park benches or bus stop benches and say, we can't let this happen. We're here to make life better. And so it is the role, the central thesis of my presentation today is that we have a tension between historical view of rights and a progressive era that is committed to making life better regardless of the rights it tramples on. Okay? Yes, Tom?
How about the phrase with the consent of the governed? You know, a lot of people argue that I didn't consent to this government, I didn't consent to this system. What would you say to that?
Sorry, I thought the question was going to be...
I don't need to be long-winded about it.
I would say that initially, the Constitution in 1789 was adopted by the 13 states. And so the people of the 13 states did consent to the Constitution. Secondly, all amendments, the first 10 and the subsequent 18, were adopted through a consent process. And, most importantly, the opportunity exists still to this day to amend the Constitution in various ways so that it does reflect the consent of the people. So I think of it, the Constitution, as having popular support, having the support, the historic support, and the ongoing support of people, of the American people. Now, I accept the observation that you don't get to vote on the First Amendment today. You were born in 1970, and by that time it was well established, maybe 1980, and it was well established. So you didn't get to vote on the First Amendment, but you can change the First Amendment if you want. Does that answer your question?
Yeah, no, that was clarified a little bit.
So,
He could leave if he really wanted to.
and you always have yes. So this worked. This idea of natural rights is the foundation of our view. So what we do at the Institute for Justice, take the eminent domain case representing Suzette Kilo. We believe Suzette Kilo had a natural right, an inherent right to her property, and the government couldn't take it away unless, under the Fifth Amendment, it was for a public use and she received fair compensation. But the Kilo case was a case about public use. When the government takes your property for a road that clearly is a public use. But that case was not about a road or a government building. It's because the city of New London, Connecticut wanted to take her home and the other 70 homes in New London for private economic developments, for a hotel, for a recreational facility that was next to the Pfizer pharmaceutical plant, for other people to have new modern homes. We thought that was wrong. We thought that she had this underlying natural right to property. She had bought it from the prior owner. It was hers. It meant something that she owned it. And so the case was about, is that right? Does that right exist? Or can the Supreme Court reinterpret the Fifth Amendment requirement of a public use to a public benefit? And then from a public benefit to, it would be good for the city of New London to take this property and have it redeveloped. I thought that was wrong. And the great news is, after losing the case, 85% of Americans thought that was wrong. And that triggered this huge backlash in 2006, where so many state legislatures changed the law. And for libertarians, people interested in property rights, losing that case has been paramount importance, because people now can understand what it is to lose your property, just like Suzette Kilo lost her property. They understand property rights just as Suzette Kilo's property rights were denied. It's real. It's the government taking your home so that Best Buy can build a world headquarters. at 494 and 35W. And so it has been of paramount importance, and really has instilled this understanding that property means something. It's a reflection of the fruit of your labor. So that's a basic on natural rights. Any other questions about Suzette or natural rights? Or does this make any sense, April?
Yes.
Okay, good. All right, so the federal government marches on from 1787, when the Constitution was first written, to 1789, when it was adopted, to 1791, when the Bill of Rights was adopted, and we get up to the Civil War, and the American people recognize that a horrible thing has happened. That we have disenfranchised a whole bunch of people. We have denied a whole class of people their natural rights. And when the radical Republicans took over the Congress after the Civil War, or at the end of the Civil War, you get the Civil War amendments, the 13th, 14th, and the 15th amendments, and you get some passion. And if you've seen the film Lincoln, you get some really great libertarian views that come out in terms of natural rights. But what the 14th Amendment does, it changes our country radically in a different direction, and I think in a really positive direction. It says to people that you are no longer just a citizen of Minnesota, you are also a citizen of the United States. You are no longer a citizen of Mississippi, you are also a citizen of the United States. And as a citizen of the United States, you have protections of the Bill of Rights, not only, I'll get to you in 30 seconds, not only against the federal government, but against your state government. Sir.
They don't talk about citizens anymore, we're all residents now. What's that?
That I think is in part an evolution caused by the 14th Amendment, because before the Civil War, you were first and foremost a citizen of Massachusetts or of Pennsylvania. In fact, it was a different country. In fact, one of the things that comes out of the Civil War is we stopped using the word "are" and we start using the word "is." People used to say the United States are. After the Civil War, and today we say the United States is a country of 300 million people. So we were much more a group of 13 or so states. By the time Minnesota comes along, 23, 24, 32? Good man, thank you, Edgar. 32 states. So that's a big change. So what the 14th Amendment does, and let me just point out here, point B here, it says all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. And here's the big change. It's changing. This is the federal Constitution talking about states, state governments. No state shall make or enforce any laws which abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process, nor deny any person within its jurisdiction equal protection of laws. Okay, so the most important word in the 14th Amendment in my eyes is "and," A-N-D. That we now have access. You are a citizen of both Minnesota and the United States. And with that, you have this mandate of freedom, of liberty, of protection of your natural rights, not only against the federal government, but against actions by the state governments. So let's back up to A, here on this chart. And you can see that, that what I mean by this is that prior to the 14th Amendment, in a decision called Barron v. Baltimore, what the Supreme Court said is that the Bill of Rights protects you against actions by the federal government. The federal government can't abridge your freedom of speech or deny your free exercise of religion or have unreasonable searches. But the 14th Amendment changes that, and it says that now all these rights that we recognized in the Bill of Rights apply to actions against states, by state governments and municipal governments. And you, the free slave, if your rights are being denied, you can go into federal court and get your rights upheld. And so the 14th Amendment opens the door of federal courts to slaves and other freemen and says when the government continues to deny you your rights, you have a place for enforcement of your liberty, and it is in federal court. It is no longer the kangaroo courts of state controlled by local municipalities and their buddies on the bench. You have Article 3 judges in federal court protecting your rights. Makes sense?
What's in Article 3?
So, in the Article 3 deals with the judiciary. Article 1 deals, in the Constitution, Article 1 deals with the legislature, Congress. Article 2 deals with the presidency, and Article 3 deals with the judiciary. So an Article 3 judge is a federally appointed judge. Judges are not, federal judges are not elected. Okay. So the world changes again in response to state-sponsored slavery, and Americans have access, even if your dispute is with the state of Minnesota, if it violates a clause of the Bill of Rights, you can march in to federal court. So, that's enormous. Yes?
So basically you're saying, like, before the 14th Amendment, let's say I lived in the state of Virginia, they could pass a law that says that I can't say certain things. And the federal government couldn't do anything about it.
Yes, that is what I'm saying.
So basically before that, states didn't have to respect natural rights.
Yet,
According to the Constitution.
According to that the protections of the Constitution were not extended to you relative to your state government.
Do you feel the 14th Amendment was necessary?
Yes. I think we could. Now, there's an interesting, at the heart of your question is whether the Bill of Rights was written in 1791, whether it intended to apply to the protection of your rights against state government. There's some who argue, Lysander Spooner, for example, argued that the Bill of Rights always was intended to protect you against your state government. That is a pure academic argument after Barron v. Baltimore. In Barron, the Supreme Court says, nope. These Bill of Rights, this only protects you against action by the federal government. The 14th Amendment reverses Barron and says, and the Bill of Rights now applies to your protection against state action.
Well, what if the judiciary did something like repeal of Roe versus Wade?
Okay.
It'd be the same kind of thing without an amendment.
So, let's talk about that. So, Flush that out a little for me.
Well, it's just, there just seems like there's positives and negatives to that word. But,
Great. So let's talk about Roe, and we'll put it through the mechanics of the way a lawyer thinks through how this is applied. Okay. And so what happened in Roe? In Roe, the Supreme Court said that that a woman had certain rights to privacy, and that they were Fifth Amendment rights to privacy, and that they apply to the states through the 14th Amendment. And so Minnesota could not restrict a woman's decision about when to have an abortion because the 14th Amendment, through the 14th Amendment, the right of privacy, the 4th Amendment, as well as the 5th, the right of privacy is extended to the woman in Minnesota. That's how a lawyer gets to it. So let me go to guns. So the first case, Heller. Why did they choose to sue Washington, D.C.? Because Washington, D.C. is a federal jurisdiction. And so if the Second Amendment, you only had to argue that the Second Amendment apply to and recognize an individual right and apply to the federal jurisdiction of Washington, D.C. The second case, McDonald, City of Chicago, and one of the suburbs. There, the question was, does the Second Amendment get applied through the 14th Amendment to stop the City of Chicago from enforcing a handgun prohibition on its residents? So the 14th Amendment is an important vehicle for acknowledging, recognizing natural rights that are in the Bill of Rights and having them apply to the states and municipalities. Is that where you wanted to go? Or did you want it to go into overturning Roe? I'm happy to talk about overturning Roe.
no, that's not, I was just using that as an example. So, it's kind of just leaning towards the way you're talking about it. Seems like it was totally for the 14th Amendment, but also that there would be negatives. And I was just wondering, so was there not any Supreme Court rulings before Barron versus Baltimore that did not grant citizens the rights of the Bill of Rights to states, or since it was Barron versus Baltimore changed it all? I mean, I would think that there could have been other rulings that enforced that beforehand, that enforced the Bill of Rights to citizens in states.
Yes. No, there weren't. So Barron is critical, because Barron is really the first case that says, so sorry, when Maryland says you can't do this, the Bill of Rights is not there to protect you. So that's critical.
And back then, states made most of the laws.
And states made most of the
So
laws.
if it doesn't apply to states, you don't really have no rights.
But each citizen resides in a state, so what is the United States?
See, the Constitution was created to control the federal government.
Yes.
Okay, with restrictions. And the federal government, when a state applied for statehood, said, well, you have to have something like our Constitution. So the states created a Constitution that's sort of mimicking the United States Constitution.
But yes, that's very true. That's very true. But Andrew's point, this is the fascinating thing with how the Bill of Rights has come in. The federal government was tiny and unimportant, but it had this magnificent Bill of Rights. Well, come the 13th, 14th, and 15th Amendment, the 14th Amendment, all of a sudden this Bill of Rights gets turned into a really important document. as it's applied against the action of state governments.
So theoretically, before the 14th Amendment, the state government could just lock you up and not have to respect your rights in that sense.
Don't go so far. Don't go so far.
Okay.
So
there's
what,
state
the way
constitutions.
there are state constitutions and there's common law brought from England
Oh yeah.
that limits government power. So where you want to go is that before the 14th Amendment, there was no protection against state government action against you that was recognized by the Bill of Rights. Make sense?
Okay. So my example that I made earlier of the state government could pass, say, a law saying you can't be Catholic, that was a lie.
That you can't be Catholic.
Yeah.
Sure.
Okay.
The free exercise clause wouldn't protect you
Yeah. And
against that.
And there were even some state-sponsored religions in that.
There were. Very good. Very good.
That was in Massachusetts?
In Massachusetts up till, you know?
Oh, no, I'm not that good.
1836. So up till 1836, there was an established religion. I think it was Congregationalism. There was an established religion in Massachusetts. So here's the First Amendment saying there's a prohibition against the establishment of religion. We're not going to have the Church of England in this country, or the Church of Sweden, or the Church of Denmark. But Virginia had a church. Massachusetts had a church. You paid taxes that went to the Church of Massachusetts. And so you can, that's an excellent, so this freedom that's recognized in the Bill of Rights doesn't apply to Massachusetts. The Establishment Clause doesn't apply to Massachusetts. Yes.
So does the 14th allow for the United States Criminal Code to open up at that particular point? Was there no code up to that point?
No, the 14th Amendment is not related to criminal activity. In fact, most criminal activities, criminal law, like family law, the vast majority of it is in states. Now, sadly, over the last 30 years or so, the federal government has gotten involved in writing all sorts of criminal law. But it's still, even after all the efforts of federal criminal law, drug laws, even after all that.
Would they use the 14th?
They don't use the 14th.
Okay.
So the way the federal government,
How do they justify it?
the Commerce Clause.
Right.
They have the right to.
So under one of the powers of the legislature of the United States Congress is the power to regulate commerce between states, Indian reservations, and foreign countries. So what has happened is this. Now we move from liberties to powers. So the Constitution grants the federal government power. One of the powers the Constitution grants the federal government is the power to regulate interstate trade. And the idea was that you didn't want trade wars between New Jersey and New York. You wanted one common market. And the federal government's power was to make sure that tariffs weren't put up in New York that blocked trade from New Jersey. Okay? That's the Commerce Clause. Now, fast forward 225 years, and the Commerce Clause is stretched all out of proportion, and it was one of the justifications that Nancy Pelosi suggested existed for Obamacare. And gun laws were justified under Commerce Clause. And the federal government has stretched Commerce Clause, its Commerce Clause power so much that it's out of control. So shrinking the Commerce Clause power is a strategy, but it doesn't, that strategy has to deal with the powers of the government, not the liberties recognized in the Bill of Rights and through the 14th Amendment. Does that make sense? You with me? Okay. Did I answer your question?
Yes.
All right, you want to go back to Roe?
Not really.
Okay.
For the 14th Amendment, do you think that all persons born versus like born of two citizens or one citizen, do you think that was an oversight that allowed so-called anchor babies, or they intentionally did it that way?
I think it was the idea that if you were born in this country, that you have your rights recognized, and that you could by being born here, you could get access. You always had access to federal courts. So now, of course, there is a debate today as to whether people who come to this country women who come to the country just have a child, whether their children are automatically U.S. citizens. The 14th Amendment, in my eyes, certainly suggests that the experience of being born here makes you a citizen. All right, so let's talk about some of the components. Or do we want to take a break? We good? All right, we'll talk about some of the components of the 14th Amendment, and we'll try to apply them to a couple things going on today. So, I'm sure you've heard of the idea of equal protection of the law. And this is the idea that, at the time of the 14th Amendment, that black men were equal to white men, and that they should be treated equally under the law, that likes get treated alike. Things that are similar get treated under the law similarly. The very definition of justice from Justinian is that like things get treated alike. And so what the 14th Amendment says is we're not going to look at the color of a man's skin as a criteria to say he should be treated differently, which historically is what slavery did. Slavery said the color of your skin means that you're property. You're not human. You don't have natural rights that are recognized. And so like things get treated alike. Now, of course, today we have this great debate about gay marriage. And you hear the same sort of arguments in this debate. You hear proponents of gay marriage saying two men are just like a man and a woman, or two women are just like, because they're humans. By contrast, opponents of recognizing gay marriage say, no, two men, just like a man and a woman, these people can do something really important. They can procreate, and these people cannot procreate. And so even today, 150 years after the adoption of the 14th Amendment, and a lot of constitutional law is a question of equal is this group, are these people really similar to these people? And if they are similar in important ways? Are they different in important ways? If they're similar, they should be treated the same under the law. That make sense? Yes?
That's how a lawyer looks at it.
That's how a lawyer looks at it. This is all how a lawyer looks at it. There's a little bit of economics here, but we'll get to that. All right. The due process of law, from the Magna Carta, the law of the land. This is the idea that when you're interacting with the government, you are due, you can expect, you can depend upon a certain amount of process. Your claims being heard, your objections being heard. So the classic contrast in this idea is you're charged with murder in a state that has capital punishment, and you're charged with a parking ticket, a parking violation. In a parking violation, you've got about 15, if you go down to the courthouse, the judge is going to give you 90 seconds. That's all the process you are due. If you are charged with a capital crime, you get to meet the prosecutor, the government gives you a lawyer, the government pays for the lawyer, you get a hearing at the district court, you get a hearing at the Court of Appeals, you get a hearing at the state Supreme Court, you can file a petition for habeas petition, and you can go into federal. You get a lot of process. Why? Because a parking ticket, you lose a little property. In a capital crime, you lose life. So in the life, liberty, and property spectrum, a parking ticket is a little property. Your life is a big deal. And the government is taking it, both. Taking a little bit of your property, taking your life. Therefore, the due process clause protects you when you're interacting with the government. Does that make sense? Okay. So if you're a slave and you're freed, and all of a sudden you run into a Jim Crow law that says no Negroes can stay in this hotel.
No, it's just a clarification. Is that a law made by the state legislature, or is that just a rule made by the owner of the hotel?
Law.
Okay, law by
Okay.
state legislation. Okay.
So here's the, yes, good point. I'm a big
Because there's a
fan.
difference, right?
I'm a big fan of giving people the opportunity to do silly things, like discriminate. If they want to discriminate, they should be free to discriminate on any basis. But what makes slavery unique, what makes Jim Crow laws unique, is that you have the power of the state in support of the discrimination. You cannot have slavery unless you have the government endorsement of slavery. And that is what the 14th Amendment was supposed to break, the state endorsement of this corrupt institution, denying people of their rights. So what happens is you can't get a room in the hotel, in part because it's endorsed by the government. The 14th Amendment is supposed to crack those doors open for you, at least crack open it as it relates to the state government's endorsement of that type of discrimination.